The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone. My name is Amy Blake. Today I am joined by Justice Maureen Walsh and Justice Rachel Hershfang. We are your panel for this case, which is being heard on the Zoom platform. And at the conclusion of this case, we will be headed to the courtroom to hear our remaining cases on today's list. The case we're going to hear on Zoom is docket number 22P240, the Department of Children and Families and Another versus Mother. We have experienced counsel, but I please remind you that the case is impounded, and so please do not use the names of any of the parties. With that said, Mr. Campbell, I will hear from you first. Thank you.
Good morning. My name is Alan Campbell. It's my privilege to represent Mother in this direct appeal, where she is seeking vacation of so much of the order as terminates her parental rights, and also expansion of visitation post-adoption, should you not agree with our first claim. Essentially, there were three problems with the decision to terminate Mother's parental rights in this case. The first is that the court did not make sufficient or adequate findings excuse me, as to why termination as opposed to guardianship or some other resolution was in the children's best interest. Mother was admittedly unfit at the time of trial. She stipulated as such, and in closing didn't argue for this. But as the court is probably aware, a finding of unfitness does not mandate a decision of termination. Although the court's findings are very detailed as to Mother's unfitness, what the court does not address is why termination was in these children's best interest. And I know that the judge in the wrapping up his conclusions of law states that they need stability and permanence, but that applies to any child. That's not findings. That's not adequately describing a decision. That's stating the obvious. And Mother agrees the children should have permanence and stability.
Mr. Campbell, if you read his findings as a whole, isn't it a reasonable inference based on, and I completely respect the fact that Mother was able to say, I'm not fit, that's a hard thing to do. And so she certainly deserves credit for being able to recognize how her own issues were impacting the children. But if you look at the findings as a whole, it seems to me that there's a reasonable inference that her issues, and we don't have to go through them in detail because you explain them and essentially concede them, that collectively, that's not in the best interest of the children. And like we say in so many cases, how long do these kids have to wait? And these are older kids. How long do these kids have to wait until Mother's able to resolve these issues? It seems to me she's had a long time. She's made strides. She's had setbacks, not inconsistent with what we understand the science to be. So help me with that.
Well, my argument isn't they shouldn't have terminated because Mother might turn things around. I'm actually, for this argument, I'm assuming that things will continue as they will, essentially. How does terminating the rights of a 15-year-old who can't even be in a foster home and wouldn't be able to be in a foster home for at least 6 to 9 months after trial, who's been in 15 placements, and who the department has had custody of since 2016, and Mother had stipulated in 2017 that she wasn't going to contest a guardianship. They've had, at the time of trial, they had 4 years to find a placement for him, and they hadn't done so. That's the real issue here. Terminating the rights.
It's not terminated, right? Doesn't she have the right to participate in a review and redetermination, an annual 29B hearing, so that she would still have a say? And reading between the lines of the department's brief, if she's not in the place to be able to take them, how could she meaningfully participate in these proceedings. Is that not the reason why termination is in their best interest?
Well, the judge didn't say that. And I might be in a slightly different position if the judge had said that, but they didn't say that. But remember, this is a mother who, although she wasn't entirely honest about her substance abuse during part of the trial, but then by the end, she had admitted that. And the judge described the woman as an open book. She admitted that she had made bad choices and she had hurt the children. She has never done anything to try to disrupt a placement. She has always encouraged the children to be comfortable in their placements. So this isn't a situation where you have a parent saying, I'm coming to get you, I'm always going to be there for you, you'll be with me soon, don't trust these people. She has allowed the children to flourish as much as they could in their placements. She just wants to be a voice in their lives. The DCF would still be making most of the decisions if you agree with me. Remember, she's agreed to a guardianship and that she won't contest the guardianship.
But the reality is, in a guardianship, the word permanent doesn't mean permanent in the world of guardianship. So if her rights weren't terminated and there was a guardianship, she could come in at any time in the probate and family court and file a motion to revoke it, even though she's said in the DCF proceeding, I won't contest it. As a matter of public policy, that's not enforceable.
But she signed a contract saying that she wouldn't contest it for a period of time, and that after that period of time, there were a series of steps that she had to do before she could contest it. One of those was documenting 12 months of sobriety.
That's not preclusive to her ability to come into the probate court and seek a modification.
It's not, but I'm sorry, I didn't mean to interrupt.
No, that you knew where I was going.
However, that agreement was in place for 4 years prior to the time of trial. So mother didn't come in to try and to change it or to request custody of them because mother knows that she's not able to care for the children. But that doesn't necessitate termination, especially as to the older child. How is the older child, if this court affirms now a legal guardian, better off being, not a legal guardian, being a legal orphan? How is the child better off? How is that in his best interests? Where the DCF has had, at the time of trial, 4 years to find a placement for him and was unable to find even a foster placement for him.
I'd like to ask you a question, Attorney Campbell, about the older child as it relates to the termination. Your argument about his challenges and his lack of adoptability was very passionate and well supported. And obviously this is a situation that's been very challenging for this family for a long time. I didn't see a citation to any cases, and I didn't find one that talks about the child's adoptability as a factor that the judge should be considering in terminating parental rights. Did I just miss it?
I'm not certain that there is a case directly on point. Maybe this will be that case. But if you're looking at everything and you're always looking at the best interests of the child, freeing a child for adoption who can't be adopted in all likelihood, that there needs to be an explanation for that. And I think for a child like the older child in this case, to terminate mother's rights at his age and with her situation, not take her situation out, but to terminate for a child like this who's not adoptable, I think what you would need to have is a parent who actually has exhibited some malice towards the child, or there's some indication that would be a problem going down the line if there wasn't a termination. As Justice Blake has mentioned, maybe they'd be filing litigation, so the child would be subjected to ongoing litigation. But we're here where you have a parent who has actually, although she doesn't want her rights terminated, she has actually supported DCF in their efforts to raise her children. She loves her children. How often do you see DCF start their closing argument by acknowledging how much mother loves her children and how she wants her children to be in a good position?
But to Judge Hershfang's point, and I don't know that there's a reported case, but anecdotally, thinking about these cases and the various fact patterns and challenges of these cases, unfortunately, would you agree with me that there's a subset of children, like the older child in this case, that perhaps the placement when he's of the right age is in sort of, and I'm going to ask the department this, so be prepared, Ms. Kernan, independent living in a group home sort of setting with other similarly situated young adults. Often those children then sign on to services when they hit age 18. We see that in other cases. So you haven't used the word legal orphan, which I appreciate because I do not believe there is such thing defined in our case law. I'm very aware of where this young man sits in terms of the viability of an adoption, and Judge Hershfang explained that beautifully, but in and of itself, they're not the greatest, but there are placements. How does that work with your argument?
Well, that doesn't shoot down my argument. I believe if you look at the record here, mother would be supportive of such a situation. Which
But
again,
without a termination, she could walk up and sign him out and say he's done, coming home.
we know she's not doing that. We
Well-
have 4 years documented where she could have come into court and say, I want custody again. And she wants to be their mother, but she knows she can't take care of them.
And I don't wish any harm on your client, but prognostically, her substance use disorder gets worse. She ends up in another bad relationship. And the jerky boyfriend says, come on, let's go get him out. And she does. I mean, she does have a history of making some bad decisions when it comes to the men in her life. I hear you loud and clear, but it's that balancing act that the judge in the first instance in the probate court did. And maybe it wasn't stated as artfully as it could have been, but I feel like the pieces are there.
Well, I would disagree.
You know,
And it ties into the other two problems, is that the court didn't give adequate weight. We made a legal error in the findings, stating that for a child that's 10-year-old, I might consider their position. Boilerplate statement of law, not followed by any discussion of what impact the children's positions had on this case, which also ties into the third problem, is that the children's position weren't made known to the court. The court heard evidence from various people saying this is what we think the children want and this is what they've said, but counsel for the children did not put forth a position for them.
But is that mother's argument to make? It would seem to me that would be the argument that the children's counsel could make, and yet we don't hear them here making it.
From children's point of view, they would be making more exactly the argument that was in Flora, which would be an ineffective assistance of counsel. This is mother saying, these are my children who have legal rights. Their rights are not being honored because counsel is not putting forth a position. Obviously, she thinks that had their position been put forth, it would have helped her. But that's not necessarily true. But the court did not hear from children's counsel what their position was. And especially where you have, at the time of trial, a 12 and 13-year-old, I believe, who could stop an adoption or a guardianship. The court really needed to hear from them in some fashion, even if it was just an informal come into the chambers. Hey, hello, what are you doing? What would you like to have happen? Would you like to live here? Would you like to live there? Some questions like that, which I'm sure you've seen many times in other cases. And I'm not, as DCF suggests in their brief, saying that you need to put the kid on the stand and say, should we terminate mother's rights? That obviously that's not the type of question to put to the children. But the court deserved, or needed rather, to hear from the children directly or through their counsel as to what they wanted to have happen.
let's
And that
assume
just-
they both told the judge unequivocally, I want to go home with mom.
Okay,
It gets weight. It's not outcome determinative.
right.
Is it-
I know it's not outcome determinative, but it's entitled to wait. And if you go through the judge's findings, as I said, the judge says a 10-year-old's opinion may be considered. Boilerplate statement of law followed by no discussion. The law actually is the children's positions shall be considered.
Counsel, something strange just happened with the clock. When I looked, you had 2 minutes left, so I'm
Okay,
gonna
so-
let you, and I apologize. Oh, there we go.
There we go.
Somebody heard me.
So even though it's not outcome dispositive, the court needs to do it, especially in a case like this where the children are of these ages. There was some mention in the findings of what the evidence was of what the children had said. That's actually not the same as the children's position. They had a lawyer standing up in court to present their position, and they didn't do so. You know, a closing argument, would you like to make one, counsel for the children? No, I'll just file proposed findings and then didn't do so. No opening, no closing, essentially no cross-examination, no witnesses. None of the questions addressed what the children wanted to have happen. And I agree, it's not outcome dispositive. I'm not saying this is dead on. This is what should have happened. But the failure to even consider it is an error. And that goes along with the other argument that I've made. It's really a sum of these three pieces. There's no smoking gun here that causes me to win. But when you look at these three issues in combination, this court should not have confidence that the decision to terminate was not an abuse of
Do
discretion.
you agree that your arguments as to the older child are moot because as we understand it, there was a resolution and there was a stipulation of dismissal with prejudice as to that child?
No, there wasn't. It was only as to that child's appeal. Mother is still seeking to turn.
That's why I was clarifying. Okay.
Right. That was just for the child's appeal. Mother's appeal is not. She still wants that the termination vacated. And then just very briefly, the order which called for visitation, which could have been limited to virtual visits, I think is wrong. They should have allowed for in-person visits as well. One of the things, very quickly, I'll go over 2 seconds. The child says that nobody at his placement can hug him. A virtual visit would allow him to have somebody to hug him. And I see my time has expired.
Thank you, Attorney Campbell. Again, I'm sorry about that clock, but I think
not a
we got it in. And we have the rest of your argument on your brief.
Thank you.
Attorney Kernan, you have 10 minutes. Is that right?
Correct.
As soon as you see the clock, you may begin.
Thank you. And I do want to thank the panel and the clerk's office and parties for converting this to a remote argument. May it please the court. Jennifer Kernan for the Department of Children and Families. This court should affirm the trial court's decree terminating mother's parental rights and the order of post-termination contact because the court correctly determined that termination of parental rights was in the children's best interest and properly established a minimum amount of post-termination contact. As determination being in the children's best interest, here, because mother stipulated to unfitness, the sole issue at trial was indeed whether termination is in their best interest. And the critical question in that regard is whether the evidence clearly and convincingly demonstrates that mother would likely remain fit in the future. And here, the uncontested record does indeed demonstrate that. Specifically, again, uncontested, the court found that the children had been severely and repetitively exposed to emotionally abusive and neglectful conduct while in mother's care. Mother herself stipulated to the fact that she was unfit in 2017 and again in 2021. That's a period of.
Do you think, though, that the findings are as clear as you've just laid them out?
I do. And I think looking at the court's rationale, I believe it's pages 53 to 54 in the record appendix. There are 3 pages in which the court discussed the reasons why the court believes that termination is in the children's best interest. And though that rationale is supported by the findings, the uncontested findings, which do, again, they're uncontested, and they do support the determination that mother's unfitness is likely to continue to an indefinite certitude. And here, as Attorney Campbell mentioned, mother's not arguing that she will become fit. So not only has mother conceded that she's unfit, she's also conceded that she's unlikely to become fit. And that's really the main point in assessing best interest.
What of Attorney Campbell's point about the older child, though? I mean, I hope the department would agree that the past 4 years are probably indicative both of the mother's likely continued unfitness and of the department's likely ability to find a permanent family for the older child. So what is your response to the point that that terminating mother's parental rights with the older child isn't really advancing his situation in terms of finding him a stable and permanent family.
So to the first point that the 4 years are indicative of mother's sort of standing, yes, the department agrees to that wholeheartedly. But the department doesn't necessarily agree as wholeheartedly that the 4 years that the older child has been in his placement are indicative of the department's ability to locate an adoptive resource. There is evidence that the child had been improving at the time of trial, had been improving in his placement. And the reason he is in that placement is because of essentially because of mother's neglectful care, that the level of care that he received while he was in mother's care.
But I don't think, I mean, just to respond to that point, Attorney Campbell has been brutally honest on behalf of his client about what a limited remedy she's seeking here, that she is not looking to raise her own child. She is just looking to remain his mother. And so I think positing, on the one hand, the department, and on the other hand, the mother, isn't really a fair way to look at the situation, right?
That's a fair statement. With regards to mother's desire to sort of be a mother, that involves sort of having some sort of capacity to make decisions for her child. And here, the uncontested record and her 11-year history with the department demonstrates her inability to make appropriate decisions or to provide safe care, even in terms of making decisions for those children.
Counsel, for a moment, I guess part of the analysis in this very unusual, to some degree, fact pattern, if what I agree is a very interesting point by Attorney Campbell, is how does it help the child by terminating mom's rights, right? Because that's going to be in the child's best interest. The flip side is, how does it harm the child for mom to still be there, even if she's unfit, because there'll be a guardian? And I understand that there could be a situation where she came into court and tried to return and have the child with him. But can you address that issue for me, please? Is how does it help the child to lose the mom?
Certainly. And I think, as Your Honor noted, primarily, termination of parental rights prevents the parent from interfering via judicial process, right? Once that parent's rights are terminated, the parent can no longer bring this matter into court again and again and sort of interrupt any stability that the child may have. So there's that. On top of that, the evidence that was presented at trial shows that the older son, both children, more in particular the older son, suffers extreme disappointment and setbacks when mother either says she's going to appear for a visit and doesn't appear, or appears hours late, like she did at the Thanksgiving and Christmas visits. Here with termination, we're sort of insulating and protecting the child from further disappointment by mother. And we have examples of that disappointment throughout the 11-year history with the department and throughout the 5 years that the case has been pending with the department. So termination serves to further their stability and their chances of permanency by, one, removing the ability of the parent to come in and for lack of a better word, interfere legally. It also sort of insulates the children against further disappointment, as we've seen demonstrated by mother's failure to appear for visits or appear on time for visits. And then also, it does improve the children's ability to achieve stability and permanency, which is the primary objective with these cases. We want both of the children here to have the best chance of achieving stability and permanency. And
Attorney Kernan, what about what I asked Attorney Campbell about? I'm certainly aware of cases where children of this age end up in sort of an independent group living situation. Is that an option once this young man stabilizes?
Certainly, and that does go beyond the record a bit. But given this child's age, it is certainly a possibility. APLA, that alternative planned permanent living arrangement that Your Honor is referencing, is indeed an opportunity. And even with that APLA plan, some children in that situation will go into foster homes, as opposed to the continued residential living program here.
How
So
old,
that
could
is-
you remind me now? Is the son 16? Has he turned 17?
He's not quite 17. My understanding is that that he will very soon be 16. I'm not quite sure.
October 9th.
So he will soon be 16, and that's the age at which the independent living or APLA program becomes appropriate. So here, in terms of termination of parental rights, the courts in Uday and Yelena have indicated that there's no abuse of discretion where there's clear and convincing evidence of unfitness, and that the likelihood of unfitness is likely to continue indefinitely. And that's the situation we have here. So for those reasons, the department asks that this court affirm the termination decree, as well as the order of post-termination contact, establishing a minimum amount of contact. If there are no further questions, the department will rest on the brief.
I don't see any. Thank you. Counsel for the child.
Good morning, Your Honors. Richard Shokire for the youngest child. I only represent that child. May it please the court. The child is seeking to affirm the lower court's judgments and decrees. She herself does not challenge any of the lower court's findings. And in fact, as you heard from my sister, mother doesn't challenge these findings. Mother's asking this court to find that an abuse of discretion exists as to the court's analysis of what is in this child's best interest.
Can I ask you though, mother is somewhat suggesting that trial counsel for the child was ineffective, and I'm not clear that mother has standing to do that. But in terms of the points raised that the child's preference was not clearly stated at the trial, what's your response to that?
Your Honor, as I stated in my brief, and as you just said, mother doesn't have standing to really challenge any of that. The child is not challenging that. She believes that her desires were represented adequately at trial.
Has the child's point of view, I don't want you to violate attorney-client privilege, so if you can't answer this, I understand and respect that. Has the child's point of view changed from the time of trial to this appeal?
If I may go outside the record just a bit, Your Honor, I addressed this in the preface to my brief, where the child states that she wishes the decrees affirmed.
You've answered my question. Thank you.
If I may continue.
Certainly.
The court did perform this analysis, even though the judge is not obligated to make this analysis. He did so here, and it's evidenced by 234 findings of fact. What mother is suggesting is that there is some separate and distinct analysis and exercise as to parental fitness and best interests. However, as the standard that I put in my brief for this court, these are not separate and distinct. They are, I believe, cognate and connected. So essentially, they're two sides of the same coin. So as the analysis took place, the court's focus was hence an inquiry as to mother's abilities. And the child's best interest, therefore, bears directly on the degree of the parental deficiency. Therefore, there really can't be abuse of discretion once the judge has made this analysis. As to mother's point earlier about why TPR is in the best interest of the child, though the child's position was made very clear at trial, mother's argument is mostly hyperbole. It's she has from and I'm not trying to be pejorative of mother, but for years, she has functioned as an agent of chaos in these children's lives. I believe that the court stated finding 229, the child was subjected to an unstable and frightening environment. These are things that the judge can look into and analyze and consider. He did so, and he made significant findings of fact, especially in the 210 factors. I believe almost all of them are relevant and were subject to analysis and scrutiny. I see my time's almost up. I'm happy to answer any questions. However,
Let me just check with the panel. I don't see any additional questions, and for all of you, you fully addressed these issues in your briefs, all of which were excellent. So I thank you for that. This is a tricky case, really sad, and I appreciate how hard you worked on behalf of all of your clients. So we will take the matter under advisement and conclude this hearing. And for those listening, we'll be hopefully out on the bench in the courtroom in just a few minutes. So thank you all.
thank you.
Thank you.